Justices Sotomayor, Kagan, and Jackson acknowledge that the historical record is mixed, but they accuse the majority of distorting facts. For example, the majority opinion says that Senator Lyman Trumbull, one of the authors of the 14th Amendment, thought that Section 3, quote, provided no means for enforcement in itself. But that wasn't Trumbull's only statement on the issue. Senator Trumbull also said although Congress could pass a law that would provide a, quote, more efficient and speedy remedy for disqualifying a candidate, in his opinion, the 14th Amendment was self-executing. And they disagree about the other clauses of the 14th Amendment. The liberals emphasize that the majority's ruling is inconsistent with how the Supreme Court interprets other clauses of the 14th Amendment. For example, basically all of the other rights secured by the 14th Amendment, like equal protection and freedom from enslavement, don't require Congress to pass legislation in order for them to exist. Quote, similarly, other constitutional rules of disqualification, like the two-term limit on the presidency, do not require implementing legislation. And perhaps the strongest argument of the dissenting voices is also the simplest. It's the textual argument that since Section 3 says that if the disqualification exists, then Congress can lift it with a 2/3 vote. You can argue that this means that Congress has just one role, and that's lifting the bar. The liberals say that giving Congress the ability to remove the bar by a supermajority doesn't make logical sense if they must first impose the bar by a simple majority by passing legislation in the first place. Quote, Section 3 provides that when an oath-breaking insurrectionist is disqualified, Congress may, by a vote of 2/3 of each house, remove such disability. It's hard to understand why the Constitution would require a congressional supermajority to remove a disqualification if a simple majority could nullify Section 3's operation by repealing or declining to pass implementing legislation. Even petitioner's lawyer acknowledges the tension in Section 3 that the majority's view creates. And while I find this argument persuasive, I think it also hints at some hypocrisy of the liberal justices. Because if Section 3 is self-executing and doesn't require implementing legislation from Congress, then there's no reason for the justices to sign on with the outcome of this case and make it unanimous. It looks like all 9 justices wanted to reach this particular outcome, regardless of how they got there. But the justices do disagree about whether the issue decided was even before the court, and the liberals take issue with the majority's decision to consider questions about what Congress is allowed to do, since that issue was not quite before the court. Quote, although only an individual state's action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. Their concern is that the majority acted like a legislature. Quote, the majority announces that a disqualification for insurrection can occur only when Congress enacts a particular kind of legislation pursuant to Section 5 of the 14th Amendment. In doing so, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides momentous and difficult issues unnecessarily, and we therefore concur only in the judgment. Now, there were probably worse ways for this court to make this decision. For example, we can probably be glad that the court did not rule that the president isn't an officer of the United States or that the presidency is not an office under the United States. And there's no text explicitly saying that the states can't disqualify candidates for federal office, but Section 3 is so vague that the court pretty much had to make it up, which is why the 9 ruled that it was just too risky to disqualify Trump. And what's interesting is this ruling on Trump's eligibility has been covered extensively